welcome to the Law Matters. Of course it does. Hi, I'm Debbie Moraes, your host and moderator. As we tell you, this long-running program had been created to educate, inform, and help you with law matters because the law matters. Understand the law better, and you're in a better position to decide how to protect yourself, your family, and your business when it matters. In each segment, we continue to provide information and resources that will help you decide whether or not you want to contact a lawyer. In some cases, you may decide to go it alone, do it yourself. If you do decide to retain outside counsel, we hope that you will be better prepared, and so will the counsel that you select. Our goal is always to help you save time, money, and to achieve the best possible results. And we want to welcome again and thank attorney David Bazar from the Bazar and Associates law firm in East Providence as he continues to weigh in on the various topics that we address. He is also an experienced mediator. Our topic for today. There's a difference in their roles. We'll discuss them. So today our topic is mediation. It's also referred to as part of the alternative dispute resolutions. We're talking about reasonable solutions, maybe achieving an acceptable outcome, maybe even something that might be chalked up to a win-win if there is such. What does that actually mean? What's that process about? Sometimes it's considered to be used in civil cases, it's divorces, it's real estate, it's contracts. There's a wide range of opportunities to use it. What do you need to know in order to engage in it? We'll discuss that. We know that you can't always be successful when you're trying to resolve differences, but imagine what can happen when people can actually communicate. It's certainly easier than going through litigation and that costly and draining and time-consuming process. So today we're going to focus on mediation, but we may also touch on arbitration. So David, help us set this up by explaining what the differences are between the two.
The differences between mediation and arbitration are in arbitration, there's usually an arbitrator or a panel of arbitrators who actually listen to a presentation by both sides of their case. It could even be in the form of a mini trial. And at the end of that trial or hearing, they write a decision that can either be binding or non-binding. Whereas mediation is a meeting of the parties where the parties will try to settle the case through a process that the parties control, not the mediator as opposed to the arbitrator.
Do people go through the same kind of process as they're preparing for either one?
Well, if it's a binding arbitration with a trial process, then you really have to be prepared with all of your witnesses and evidence. If it's mediation, you still have to prepare, but it's not like preparing for a trial. It's preparing for a couple of things. Number one, which is to have your attorney, or if it's you representing yourself, make your best argument about your case that's presented to the mediator and to the other side, perhaps. But it's also knowing what are all of the expenses of your case, the downside to your case, the cost of going to trial, so that you can weigh and balance that as opposed to what the settlement needs to be to satisfy you versus what you might end up doing at trial.
So let's focus on mediation. And I said at the introduction, the initial comments, which included that we know you're a lawyer, but you're also a mediator.
That's correct.
So you can be one or the other, but I understand you can't be both at the same time. How do you work with clients to determine, or who determines, I want David the mediator versus I want David the lawyer? Is that to discuss between the two of you to decide which is best? How does that play out, David?
Usually, if it's a mediation and it's involving a case other than perhaps a divorce, for example, the lawyers will contact me. So we know that they're contacting me to do a mediation. If it's a divorce mediation, sometimes one or the other party will contact me and they'll ask about mediation, and I'll explain to them that if you want to have mediation and you want to hire me as a mediator, then both of you have to come in together to talk to me so I can explain the mediation process to you, and for both of you to hire me as a mediator. Because if you want to hire me as an attorney, as you said, then I am not going to be the mediator.
And when you began that statement, you said sometimes the lawyers will contact me. At that point, those lawyers can't ever be the mediator, right? Because they've already been serving as the lawyer.
You can't mediate a case that you were an active attorney in. Conflict of interest and all sorts of other issues and problems that would arise. So you're correct. You're not going to be an attorney and a mediator in the same case.
So if you are someone's lawyer, under what circumstances might you hear or say you can mediate this? It's a divorce or it's a business contract. Would you end up being the person who would say, maybe this doesn't need to be a legal case, maybe you should? Would you ever be the person who would suggest that something be mediated if you were already serving as a lawyer?
If I'm the lawyer, oftentimes we will explore with our clients the advantages of, as you called it, alternative dispute resolution, whether it's a mediation or an arbitration, and it depends on the type of case. You're not going to do an arbitration for a divorce case. It's either mediation or try it. An arbitration doesn't work because at the end of the day, an arbitrator can't enter a decision for a divorce. So if you want to resolve it with alternative dispute resolution, usually it's going to be in the form of a mediation. And there are different forms of mediation that can be used. I'm going to, in this case, talk about private versus court mediation, because court in Rhode Island, the family court, has a mediation built into it. In certain cases are required to go through mediation. Mandatory, right. And if you're not required to do mediation and you don't want to use the court mediator, you can privately enter into a mediation agreement with the other party and a mediator and hire them to do that mediation.
So if someone is looking or mandated to do mediation, must they pay for mediation, or is there, I understand that the Rhode Island court system has an ability or resource. How does that work versus someone coming to a private mediator?
So in Rhode Island family court, if you have what's considered a miscellaneous case or an M case, which is a case where there's a dispute between two people for usually custody who aren't married, but have a child together, both on the birth certificate. Those cases by court rule have to go through mediation, and the court mediator, the person who's an employee of the court system, is paid by the court. The parties do not pay that person privately. In federal court, for example, there are cases that require alternative dispute resolution, and there are employees of the court, whether it's a judge magistrate or some other person in the court system, who might be assigned to mediate the case. And again, not paid for by the parties, but rather by the court system.
Let's help our viewers understand. If you are if someone wants to become a mediator, what are the credentials, what are the requirements, and what do you need to make sure that your clients understand about the law, relevant law still applying?
So when I became a mediator, I went through training to be a mediator, and it was a class through Roger Williams University, and it was a very involved, in-depth class. The requirement to be a mediator, well, let me go the other way. You do not have to be a lawyer to be a mediator. That can be helpful, but it can also be helpful if you have a background in social work, if you're going to do certain types of mediation. It could be helpful if you have a background in construction, if you're going to do mediation about construction contracts. There are a number of different abilities and training that people could have that would be very helpful in being a mediator. But the most important part about being a mediator is to understand the process.
Okay. I understand that while mediation might be used, say, in the construction industry, might someone who's going to be doing that need a depth of knowledge about the business as well as law? Because I understand that when construction projects are involved with multi-office or large sites, that there can be many suits going on in such complexity that it takes a pro to be able to sort out those issues, and maybe they get one piece of it as opposed to as many suits as might be running simultaneously.
That's a possibility. It's the background that's helpful, but the training as far as mediating a case is actually as important. So if you don't know the depth of the construction world, but you understand how it works in general, and you're a good mediator, you can still resolve that case without having the experience that someone who worked in that industry may have for years. But you need to have enough experience to know when they're telling you different things of what's correct and what might not be correct. And as you said at the beginning about the law has some place in mediation, but not exactly a requirement. For example, if you're mediating a divorce, it's helpful for the mediator to know what might or might not happen at trial, but that might not necessarily be a driving force in getting a case resolved. As my trainer in mediation said, you can have a party who wants to give away the farm, meaning they're willing to settle for a lot more than they might be required to do at trial in a divorce, but they have to understand what they're giving up and why they're giving it up, and make sure that the parties have an arm's length ability to negotiate a transaction.
Okay, so I want us to talk about the process of mediation, but who actually is likely to be able to have or enter into mediation? So obviously if it starts with a dispute, two people who don't agree, depending on who they are, what their preconceived notion is, what their mindset is about, who can actually come to mediation with some likelihood of agreeing? If people are very hot-headed or what, can you still work with them, and how do you take them down off the cliff? Do you end up decompressing? Is that part of mediation?
Yeah, I think as part of the process of mediation, the only real requirement is that there's an even playing field, that both sides are able to represent themselves or have their lawyers represent them, and that they're able to negotiate fairly with each other. So there can't be, for example, one of the things that just will never go to mediation is a case between two parties where there's a restraining order for domestic abuse or something of that nature, because by nature of just that type of thing, one person who may have been abusing another may be trying to impose their will on the other. And it's usually not a good case scenario for trying to mediate a case, and something that I wouldn't take on. But for the most part, if we have an even playing field and two parties that have the willingness to sit down to resolve a dispute, then that's the kind of case that should be submitted to mediation. And what we try to do in mediation, especially in the divorce arena, is to get the parties to start listening to each other. And what we're trained to do is to make sure they're actively listening to each other. So there might be some things like one party says something and you don't think the other party's really listening, so you might repeat it. Did you just hear your wife say this, this, and this? And get them to respond to what was actually said. So once parties start listening to each other, there's a better chance that you can get to a point where they'll agree with each other on a resolution of a case.
So do you actually quiz them on the verbatim? Sir, what did you hear him say? What did you hear her say? And can you repeat it back? And then you would try to correct it if they were mistaken or incorrect or frankly just not listening? Usually,
but mostly, I should say sometimes, but usually what you'll do is to actually repeat it yourself.
You would, as the mediator.
Right.
Okay.
So that there's no intimidation factor or anything.
Okay.
We want them to be comfortable. But then if I don't think they're getting at that point, I might say, so how did you understand that? So that it's not a quiz, but it's just a conversation. And the point is, for example, I had a case where they came in about visitation among many other issues, and they agreed on weekends and holidays, this, that, and the other thing, but they wanted visitation during the week. And I believe, if I'm remembering this correctly, the wife wanted the visitation on Wednesday nights, and the husband wanted Tuesday nights, and back and forth. And so finally I said to the wife, or the husband, why do you want Tuesday nights? Well, because on Wednesday I have this commitment. And he explained what the commitment was. And the wife looked, she said, I thought that was on Thursday nights. No. Oh, all right, well then Wednesday night's fine. It's the communication.
Communication.
And that's helpful for after the mediation in that kind of case where they have to continue to communicate.
Should I ask this? I'm going to. Is there ever a chance that when you've had these conversations with people who are coming to you for a divorce, that since you've helped them open up the lines of communication, that they don't end up getting divorced? Does that ever happen?
It has. But what I used to say back in the day, it's more likely that you'll get divorced, but that you may end up getting remarried.
Interesting. So let's go through what that process is. So two people have come to you as mediator, not as lawyer. How does the process begin?
So as I said, if it's two parties, which is very different than two lawyers.
Yes.
So we'll do the two parties first. And usually when it's two parties, it's usually, not always, it could be a business dispute, but usually a divorce. And so I would meet with both of them at the same time so they understand that I'm not representing either one of them. Even though I'm an attorney, I'm not acting as an attorney. And I would describe the process for mediation. And the process for mediation is generally, I give them some forms in a divorce mediation so that they can give me all of the issues, assets, and liabilities, so we can address all of the topics that need to be covered in a divorce mediation. And I explain to them that what I do in a mediation is first I sit with both of them and I listen to a little bit of what they each have to say. And then I'll break them into separate rooms, caucuses. And I'll go, we might even call it shuttle diplomacy, and go back and forth with each of them for certain things that they may want to tell me, but they don't want to say in front of their spouse, perhaps because they don't want to insult them or hurt their feelings, or they don't want them to know everything that they're thinking.
So, excuse me, would that happen in session one when you're establishing the opening statements and the ground rules or whatever? That could happen on that first session?
Yeah, usually the first session
Yes.
is for me just to explain mediation.
Okay.
And we haven't started yet because they haven't hired me yet.
Okay.
Usually I'll meet with them to talk about how it works,
Yes.
what the process is, and what the advantages of mediation are. But then what you're talking about, opening statements, so to speak, and all of that, that's day one.
That's day one. And do they individually have to prepare a statement apart from their assets and liabilities?
So in a divorce mediation, I don't usually ask them to make a statement.
Okay.
Now, just quickly jump out of that one for 1 minute. If it's I'm mediating a settlement for a personal injury case, perhaps. In that type of situation, then day one, that is the case, because the lawyers don't need me to explain to them what the advantages or disadvantages of mediation are. So day one in an auto accident mediation, the lawyers will come in and they will make an opening statement. They will lay out their case, not only for me to hear, but for the other side to hear. And what I will do at the beginning of that is, before anyone says anything, I'll explain to the parties, I'll thank them for coming to mediation, I'll ask them to keep an open mind, and I'll ask them to listen to what the other party has to say about their case so they understand where they're coming from, and I'll ask them if they have any questions about the mediation process. But I don't go in as much depth with the parties as I would when it's no lawyers involved, because the lawyers will have given them a lot of explanation. And then we'll do those opening statements, and then we'll separate into separate rooms.
And might this take, is that session likely to be an hour, 2 hours?
We're doing the one with the lawyers and a personal injury settlement. It could be a whole day.
It could be a day. So most, if someone is paying a mediator, obviously they're likely to pay by the hour, or is it by the case? Because in some cases it might be a very quick wrap, hopefully. Other times not. How does that get priced?
So if I'm doing a mediation for a divorce, and I'll meet with, like I said, I meet with the people, no charge first.
Yes.
First of all, for me to find out what the issues are, and for me to explain how mediation works. And once I've got a good sense of what it is I'm mediating, I oftentimes, in those cases, will give a flat fee. This is what it is. We'll set up session one. It may take session two. If it's complicated, it might be several sessions. Mediation with attorneys involved, it's usually hourly.
Yes, and I imagine that becomes a lengthier procedure at times.
It could be, and also they'll split the cost.
Safe to say, even at that point, that mediation is less expensive and less time-consuming than if it goes into the court?
Yes, and it's also more certain, because if you go to court, Now you're preparing for trial, so you're paying all the expenses to prepare for trial, and then you're going to pay all the expenses necessary to try the case, which may include expert witnesses, it may include subpoenas, it may include all sorts of things that will take time, including the attorney's time and money to pay them. And so at the end of the trial, it's either in the hands of a judge or a jury, and you don't know how they're going to respond. Whereas in mediation, if it's going to settle, it's because both parties want it to settle. And so you know how it's going to end. And you at the beginning said you try to resolve it on sometimes a win-win situation. Well, yes, always, because it's a win-win when it settles because both parties know that it's been settled. They may both either be unhappy or happy, usually both a little satisfied but disappointed,
Fair enough.
but happy that it's resolved.
And in arbitration, though, might not be win-win, right?
If it's binding arbitration, it's sort of like a trial. You're rolling the dice. It's in somebody else's hands, as opposed to mediation, which is in your hands.
So staying with the idea of mediation, someone's presented what they want to you, the other side has, you've given them the list of things, the details to fill out. Who determines what the most critical issues are? Is it you likely to say them, from what I can see here, these are your key areas of dispute? Do you agree? Do you agree? And where do we go from here? Is that how that would likely occur in the next meeting session, or third or fourth or whatever it is?
Yeah, it depends on the type of mediation. In a divorce mediation, here's one of the things that I always tell them at the beginning. I'm an attorney. I'm not going to give you legal advice. If you have questions as we go through this process, hire an attorney, have the attorney available to you so you can ask those questions. Just like I'm not an accountant, I'm not going to give tax advice or financial advisor to give financial advice. I will give you guidance in the right direction and make sure you know what questions to ask, so that when we're going through a divorce mediation with just the parties, issues may come up and they may have homework, like the husband might think the house is worth X number of dollars and the wife might think it's worth X plus Y number of dollars. Well, you know what? You can hire an appraiser if you can't agree on the price.
And you might suggest that.
Absolutely. And if there's a legal issue about alimony, is that tax deductible or not tax deductible? Talk to an accountant. Those rules have changed.
So you would likely refer them elsewhere if that's what it comes down to, if that's what's needed.
Yeah, so, I mean, if it's a real simple issue that they both just want the answer on, I
Yes,
would
you
help
can.
with that.
Yes.
But if it's complicated and they need advice,
Different.
that they're going to need to speak to either their own attorneys or an accountant or somebody else.
So if mediation is about, let's get to win-win, still, I want to win. David, I'd like to have a private meeting with you. Doesn't that set the other side up to, well, how about me? Don't I need to have one too, lest I feel that that's not being well balanced and represented? Does that happen? I mean, do people feel like, how does that work?
As opposed to trials with a judge or arbitration, judges would call that an ex parte meeting, meaning just one party. In arbitration, same issue. In mediation, as part of the process, after you've hired me, not before, but after you've hired me, we will meet alone, because that's how we do the mediation. I come into that caucus room, as I called it, to talk to you about your issues and your concerns and what is important to you. Then I go to the other party and do exactly the same thing. I'm not playing favorites. It's just how the process works. And I tell the people that are involved at the beginning that that's what we're going to do, because it's their opportunity to tell me things that I need to know.
Okay, and as they're working through what seems to be something that they will agree on, if you don't feel that that is equal because they don't know, one party doesn't know what he should or shouldn't know, how do you manage that?
If I think someone's being taken advantage of, I'll tell them to go speak to an attorney. If they speak to the attorney and they come back and they're still comfortable with what they're doing, then they've been informed, so it's an informed consent, so to speak. They know what they're doing, and as we said at the beginning, or towards the beginning, that you can give away the farm as long as you know you're giving it away. So I want to make sure they know everything that they're entitled to by going to an attorney and being informed of that, and then coming back and making that decision.
So is it in contrast with arbitration where someone might look at that person who's the arbitrator and say, I'm not sure that you evaluated this properly, you undervalued, overvalued, whatever, it wasn't correct.
It doesn't really matter. It doesn't really matter what you think. If it's not binding, then you have the right to go forward with your trial or have the case resolved in some other fashion. If it's binding, it's actually very difficult, depending on the arbitration and the arbitration agreement and all of that, to overturn an arbitrator's decision. You're not going to go to court and say, yeah, he made a mistake and it's not right. I don't agree with his number, for example. And that's not really going to fly. There's statutes on that. There has to be some real egregious action and something that made the arbitration itself, the process, flawed and not right.
Good for our viewers to understand. Can you explain briefly, in the time that we have left, when, in what circumstances might you have mediation and then arbitration running, not concurrently, but one after the other?
Sometimes you can take two shots at the apple to resolve it. You have a case that you couldn't resolve at mediation by a mediator meeting with both parties, so then you say, or personal injury, what's the value of the case, or whatever, business. So then you say, well, we'll try to resolve this by arbitration.
So in business, is there mandatory arbitration that would guide and direct this as opposed to mandatory mediation?
Sometimes
when does that happen?
Sometimes in a contract that you enter into, the contract has an arbitration clause that says this is how you do it and this is what you have to do.
And when do they do binding versus non-binding?
Again, depends on what's in the arbitration clause, if there is one, or what the parties agree to.
In workers' compensation, apparently, those are cases that come up.
Yep.
There's a dispute. Are those likely to be binding, non-binding?
It's up to the parties on what they want to agree to, but the Rhode Island Workers' Compensation Court has an arbitrator that works for the court and will decide cases for you if you want.
So when we talk about mediation, you don't necessarily have to have a lawyer with you when you're doing divorces or some cases. When you have arbitration, you mentioned that you may or may not have a lawyer with you. What's your take on that? If one has one, should the other just keep that?
It depends on the type of case, but honestly, it's a mini trial in some ways, and I would always want to have an attorney to represent my points to make sure all of the things I want to get across to the arbitrator are presented correctly. Is
there ever a question about in mediation that the mediator wouldn't know the applicable relevant law of the circumstance that he's mediating? Would that ever come up so that someone could come back later and challenge it?
No, that's not really an issue in mediation. Not an issue.
Good for people to know. We thank you for tuning into the Law Matters. We hope that this has been helpful to you in making some of your decisions, whether you need mediation or arbitration. Stay tuned to the Law Matters. As we say, it matters to you. Thank you for tuning in.